Today, we are joined by an excellent panel of speakers who will reflect on state compliance with the United Nations General Assembly resolution of the 18th of October 2024. In particular, its coming to being and the legal and political consequences which may follow for states and the international legal order as a whole, now that the resolution's deadline has expired. Kicking off our panel, it is a pleasure to be joined by His Excellency Ambassador Ammar Hijazi, Ambassador and Head of the Palestinian Mission to the Kingdom of the Netherlands and Permanent Representative of the State of Palestine to international organizations in The Hague. Ambassador Hijazi spearheaded Palestine's international accountability endeavors, including at the International Criminal Court, the International Court of Justice, where he acts as Palestine's agent in several proceedings. And throughout his diplomatic career, Mr. Hijazi has participated and led Palestine's successful application to international organizations and accession to multilateral treaties and other international tribunals, including UN specialized organizations and Interpol memberships. Next, we will hear from Professor André Nollkaemper, Professor of International Law and Sustainability at the University of Amsterdam. Professor Nollkaemper leads the agenda of the University of Amsterdam to advance knowledge on climate change and, more generally, sustainability. He has acted as external legal advisor to the Minister of Foreign Affairs of the Netherlands, member of the Permanent Court of Arbitration, and president of the European Society of International Law, and has published extensively on matters of general public international law and state responsibility. Last but certainly not least, Dr. Alessandra Spadaro, Assistant Professor of Public International Law at Utrecht University, researcher in the Montaigne Center for Rule of Law and Administration of Justice. She is also a member of the Research Platform on Peace, Security and Human Rights and a core team of the Contesting Governance Platform. Dr. Spadaro's expertise lie at the intersection of international humanitarian law, international human rights law, and international criminal law, all currently being engaged in a 3-year research project titled Business in and for War, the Role and Limits of International Humanitarian Law. Thank you all so much for joining us at the Institute today and sharing your insights. But before we begin with the panel discussion, it is my pleasure to invite His Excellency, Ambassador of the Sultanate of Oman to the Kingdom of the Netherlands and Dean of the Council of Arab Ambassador, Dr. Abdullah Alharthy, to give some words of welcome. Please join me in welcoming His Excellency.
Thank you. Your Excellencies, dear guests, allow me on behalf of the Council of Arab Ambassadors to welcome you and thank you for coming. We are thrilled to be co-organizing today's event with the Asser Institute, a world-class institute renowned for its top-notch legal experts and research in private and public international law and other fields. We hope this will be the beginning of further cooperation. Ladies and gentlemen, last year, the International Court of Justice issued a landmark decision on the illegality of the Israeli occupation in the occupied Palestinian territory. The court determined the obligations of and legal consequences for the Israel as occupying power and called on Israel to cease its grave violation of international law and its illegal occupation, and in all manifestations comply with international legal obligations, including respect for the Palestinian people's right to self-determination, and make reparation for all the harm done by its occupation. Additionally, the ICJ resolved the obligation of all states and the United Nations under international law as a result of Israel's unlawful situation, including not recognizing the legality of Israel's illegal presence in the OPT, not lending assistance to Israel in maintaining this illegal situation and bringing Israel's illegal occupation to an end. This historic decision paved the way for the adoption of the United Nations General Assembly Resolution 10 by 24 by an overwhelming majority of United Nations member states. The resolution set a deadline for Israel to end its unlawful and called on states and the United Nations to adopt practical accountability measures to ensure their compliance with the ICJ decision. It was an important decision for Palestine, international law, and the ICJ. 2 years into Israeli genocide war on Gaza, and 1 year since the adoption of the United Nations General Assembly Resolution 1024, we meet to mark an anniversary of this significant resolution that aimed to achieve accountability, justice, and end Israel's internalized impunity. Our esteemed panel today will take stock of integrate the implication of non-compliance by states and the wider consequences of the international legal order. Thank you very much.
Thank you very much, Ambassador. Okay, so our panel discussion is planned to last roughly 45 minutes. Each speaker will have 50 minutes for their presentation, after which the floor will be open to you, the audience, for your questions. And there will be a closing reception after the event in the Mancini room, which is down the corridor and to your right, where the conversation between you all can, of course, continue. With that said, Ambassador Hijazi, will you do us the honor of starting us off?
Thank you, Carl, and I'm honored to be with you today in these trying times. Allow me, before I begin, to express my appreciation to the Asser Institute for hosting us today. Also to express my appreciation to everybody who took the time to be with us today, my co-panelists, and to look forward to interesting and important discussion. And last but not least, to the Arab group and our Dean, Ambassador Abdullah bin Salem, for sponsoring this event and supporting it. Well, we meet today to discuss the unlawful occupation of Palestine and the impact of states' compliance or the lack of it with the UN General Assembly Resolution ES-1024, but by extension, their compliance by the ICJ. I intend to go through a historical narrative, how Palestine was treated under international law, a very short historical narrative, and why was it important to seek an additional advisory opinion at this moment of our history? Why did we go that route? And finally, to conclude with how does the advisory opinion advance Palestinian rights? And through it, I will address also the issue of compliance of states and lack of compliance. So thank you very much. And Allow me to start by the historical narrative. International law, in its current form, is constantly developing regime of laws and principles established by countries over the past 200 years to facilitate productive political, social, and economic relations between nations and avoid, when possible, military escalation. The horrors of World War II created a significant impetus and transformation, or so we claim. The criminal tribunals were established, followed by the United Nations, the adoption of the Charter, the Universal Declaration of Human Rights, as well as Geneva Conventions, and many others that followed over the decades. The development of international law translated into obligations, state accepted to be bound with. Those are usually known by erga omnes and jus cogens norms. No derogation is ever permitted from these principles, which include norms like the prohibition of torture, the use of force, the racial discrimination, and the acquisition of territory by force. Other norms became obligations that are owed towards all, like erga omnes, including the right to self-determination and sovereignty over natural resources, to quote a few. During the years that the world was forming these norms, Palestine was casted out from them since the onset. Throughout the years of British occupation of Palestine that started in 1917 and more during and after Nakba in 1947, powerful states were eager to invoke these norms anywhere except Palestine. We were a fair game, and Palestine's attempts to become part of this system were repeatedly thwarted under different justifications. As you can imagine, we were relentless, maintained a patient, persistent, and precedent-setting effort at the multilateral forums in order to make sure that we are not casted out. Our incremental approach carved a place for Palestine in the international order, including the recognition of our inalienable rights, chiefly our right to self-determination and return through the United Nations legislations and many other routes. There were significant leaps in the past 20 years. In 2004, Palestine secured a landmark advisory ruling on Israel's illegal wall, which elevated Palestine rights to a new level, in particular by recognizing the applicability of human rights norms to Palestine. The next quantum leap started in 2011 with the elevation of Palestine's status at the United Nations, Palestine's membership of UNESCO, and then Palestine's accession to various international legal instruments, including the Rome Statute. As members of the ICC, we also referred the situation in Palestine to the court, and an active investigation is now ongoing and has produced several arrest warrants, including for Netanyahu. It has been a long and difficult journey, full of threats, attempted intimidation, and financial strangulation. Israel called it a diplomatic terrorism. In fact, it was self-defense. So why is it important to seek an additional advisory opinion? Let me start by reminding that Palestine's pursuit of the July 2024 ruling preceded the genocide, because what was at stake was clear even then. For Palestine, the main aim could be summarized as follows: to protect Palestinian people's rights, ensure that violations of these rights do not go unnoticed, and the perpetrators are held accountable, and to invoke third-party responsibilities leading to ridding our people of this brutal colonial occupation. At the core, the target was and remains to preserve and alleviate Palestine's rightful place in the rights and law-based international system, rectifying a compounded historic injustice whereby international community insisted on dealing with the question of Palestine as a humanitarian crisis devoid of any political, legal, or historical context. We wanted to ensure, among other things, that states and international organizations exercise their duties towards the question of Palestine at all levels, not as an afterthought or an act of charity, but rather as an integral component of their obligations towards international law. As we foresaw, the deliberations and ruling corrected the direct and indirect harm caused by the wrong coining of the term Israeli-Palestinian conflict, which essentially normalized occupation and gave the colonizer a free hand to continue pursuing its target of ethnically cleansing Palestine from its Palestinian people and annexing it. With minimal international resistance and under the guise of so-called self-defense or so-called security concerns that in this context have no legal basis in international law. This facade of balance between the colonizer and colonized distorted the context of the question from one of foreign colonial occupation to so-called complex conflict over territory between two parties. By surrendering to the perverse logic that shot down facts, international law, and UN resolutions, while justifying crimes on the basis of fanatical messianic ideologies and myths. This imposed an upside-down power dynamic meant that states abandoned their obligations under international law. They were derelict in holding Israel to the same standards as other states. The end result was tragically predictable. Normalized criminality and entrenched impunity that regarded systematic violations of Palestinian lives, dignity, and human rights as an quote-unquote unhelpful part of the reality. In this context, states knowingly and irresponsibly rendered pre-emptory and jus cogens norms useless and insisted that this selectivity does not undermine the international law-based order. Here, I cannot stress enough the importance of United Nations General Assembly in this battle. This body remains the most democratic legislative international forum that can and does act collectively despite the intransigence, blackmail, and bullying of powerful permanent members of the UN Security Council. That is how we arrived at the landmark advisory opinion of 19 July 2024. We secured a carefully negotiated resolution requesting this ruling adopted by the General Assembly. But how does the advisory opinion of July 2024 advance Palestinian rights? Our view is that a solid determination by the highest international court opens different conversations and possibilities for action to end Israel's occupation. The court's historic determination for 2024 facilitated collective action on the state level. It stripped them of the excuses to avoid such action before it. Crucially, it armed civil society organizations and legal experts around the world with a definitive determination they can use to pressure their governments in action that not only stands up for Palestine, but also better reflect on the will of the constituencies. A good example is the current genocide taking place against our people, especially in Gaza, where all relevant civil society institutions, scholars, UN experts, and Commission of Inquiry by the United Nations have made a clear determination that it is being committed, yet some governments continue to admittedly insist on obstinate denial of the facts and the responsibilities arising from them. Some are directly complicit in genocide and have not changed course, but all, without exception, feel the pressure and are looking for ways to relieve it. To summarize, Israel's genocidal colonial policies aim to erase our identity and existence as a people. The ICJ advisory opinion was a significant milestone in our noble endeavor to protect ourselves, our humanity, and our very existence, that corrected the lexion, shifted the paradigm, and realigned the conversation with international law. It was also a momentous moment for international law and states vested in its continued relevance and utility. It even gave reluctant actors a way out of disgraceful inaction. Some have availed themselves of the opportunity, even if many don't admit it. The solution is clearly spelled out: ending illegal occupation in line with the historic advisory opinion of July 2024 and the UN Resolution ES-10 24, realizing the Palestinian people's inalienable rights, including to self-determination, an independent state of Palestine with East Jerusalem as its capital, providing reparations as required. This is the only path to achieving peace and security for all peoples in the region and beyond. Not genocide, not sideshows, and not endless subjugation, and definitely not privatized colonization. But much work remains, and we need to keep pushing. I know that my time is up, so if you allow me to say a few words in my conclusion. In conclusion, I see it's not a few words, it's 2 paragraphs, but let me go very quickly. John Dugard, a very important jurist who fought apartheid but also stood up for injustices everywhere around the world, held the position of special rapporteur in the occupied Palestinian territory. In his final report in 2007, he said the following, and allow me to quote: "For years, the occupation of Palestine and apartheid in South Africa vied for attention from the international community. In 1994, apartheid came to an end and Palestine became the only developing country in the world under the subjugation of a Western-affiliated regime. Herein lies its significance to the future of human rights. There are other regimes, particularly in developing world, that suppresses human rights, but there is no other case of Western-affiliated regime that denies self-determination and human rights to developing people, and that has done so for so long. This explains why the occupied Palestinian territory has become a test for the West, a test by which its commitment to human rights is to be judged." End quote. Palestine remains the most important test to the credibility of international law and international system. This is a test that the international community cannot afford to fail, not just for Palestine's sake, but for humanity's sake. States that insist on non-compliance with the ICJ and the United Nations Resolution ES-10 24 insist on complicity in genocide, colonization, and apartheid. This has political, legal, and social consequences, it's no longer something you get away with. These states have to answer to their action. This is happening all over the world. Complicit actors are confronted with legal action and popular outrage. On a final and more positive note, let me share with you how the Palestinian people view all these developments and shifting dynamics. We are living extraordinary times where global solidarity and coordination on universality of human rights and international law is mobilizing and coordinating at unprecedented scales and scopes. Palestinian rights are no longer an issue of exclusive interest of Palestinians. Instead, they are part of a global conversation on international law and human rights, informing the kind of pressure governments face today regarding their obligation to respect and ensure respect of international law. It's disrupting power politics and callous policies in the most constructive and noble way possible. Palestine and the world stand to benefit. And thank you for your kindness on awarding me a few additional minutes. Thank you.
Thank you very much.
Thank you very much.
Now, of course, thank you very much, Ambassador. Professor Nollkaemper.
Can I speak from there?
Yeah, you can. Sure.
No, I should have waited.
No.
It's hard
I
to
speak
speak
easier
when
when
you're sitting.
I speak easier when I So the title of my presentation, following on the important opening works, is Power at its Limits, the Passing of the General Assembly's Deadline and the Consequences for Israel. So when the deadline set by the General Assembly in Resolution 1024 passed 1 month ago, it was quite clear that Israel had not complied with the resolution. We do not need a fact-finding committee to determine that Israel has not brought to an end, without delay, its unlawful presence in the occupied Palestinian territory. The proposal that Prime Minister Netanyahu and President Trump have submitted to Hamas does not at all suggest that this goal will be achieved anytime soon. Now, this is clearly not the first time that the General Assembly has asked Israel to comply with international law, nor is it the first time that Israel has failed to do so. Far from it. So in this situation, there are three questions before us. What is the legal nature of the deadline set by the General Assembly? Second, what legal and institutional consequences follow from the expiry of the deadline? And third, if the General Assembly keeps asking the same thing over and over again, and if Israel keeps neglecting what the General Assembly demands, what does this tell us about the authority and relevance of the General Assembly and international law more generally in relation to the illegality of occupation? I will take these questions in order, so I will proceed in three parts. And taken together, these parts present a fundamental tension. On the one hand, the General Assembly has attempted to use its powers to the full extent allowed under the UN Charter. On the other hand, precisely this attempt exposes the limits of what the Assembly and international law more generally can achieve. Yes. So this brings me to my first part, entitled the General Assembly. Thank you. Thank you. The General Assembly at full stretch. So the easiest thing to say would be that Resolution 1012 is just another General Assembly resolution, that under the UN Charter is not binding. End of the matter. But clearly that would be much too simple. Resolution 1024 was not just another resolution. In three respects, it is rather unique. First, it was adopted under the Uniting for Peace mechanism, which is an open agenda point in the General Assembly. This strengthens the status as an expression of the collective judgment of the international community acting in the face of the paralysis of the Security Council. In procedural terms, this gives the resolution a quasi-Security Council status. A declaration issued under an exceptional mandate to preserve peace. It does represent the Assembly acting at the outer edge of its constitutional authority under the UN Charter. This clearly was the best shot that the collectivity of states in the world had to try to achieve the goals that the founders of the United Nations set 80 years ago when the UN Security Council does not act. The second point that makes the resolution special is that its demands incorporate the prior determination made by the International Court of Justice in its 2024 advisory opinion. The resolution largely transposed the court's findings into a political form, reaffirming the unlawfulness of the occupation, demanding its termination, and recalling third states' duties of non-recognition and non-assistance. So we can say that the General Assembly borrowed the legal authority of the International Court of Justice to bolster, to strengthen its own political determination. And the third point that makes the resolution unique is indeed the deadline itself. In all earlier resolutions, where the Assembly called on states to do something or not to do something, it used the language immediately or without delay. It never used a specific, state-specific deadline. When the Assembly did use deadlines, it did so in respect of other organs of the United Nations, in particular actions of the Secretary General. So in this respect, Resolution 1024 breaks precedent by imposing a state-specific deadline. And that deadline has operational meaning. It gives the General Assembly, and by extension third states, a temporal benchmark for determining that Israel's non-compliance is manifest and continuing, activating the duties of non-recognition and non-assistance under the court's advisory opinion. So in sum, on this first point, Resolution 1024 stands out. It's a quasi-Security Council act that borrows the court's authority and fixes a concrete temporal benchmark, demonstrating that the General Assembly used all powers and procedures that were available to it. That brings me to the next question, the second part. Pushing the limits, consequences of non-compliance. So here we see that once we have determined what the legal status of the deadline is, what the Assembly can do to achieve compliance. Now here we see the General Assembly testing the limits of its authority. Clearly, the General Assembly cannot enforce compliance directly. It simply does not have the powers to do so. But what we do see is testing how far it can go in generating consequences from a position of structural weakness. So for a starter, first, it could formally determine non-compliance. It has done so on many earlier occasions. For instance, here, after adopting Resolutions 2253, which called upon Israel to rescind measures altering the status of Jerusalem, the Assembly, only 10 days later, determined non-compliance, deploring the failure of Israel to implement the resolution. It could do so again in this case. The important point of such a non-compliance resolution would be that it would not only be a finding of non-compliance with the resolution itself, but also a finding of non-compliance with the advisory opinion of the court. And that is important because the court itself will rarely be in a position to determine non-compliance with its own judgments or advisory opinions. Moreover, and this is somewhat speculative, but moreover, the General Assembly could combine a finding of non-compliance with a determination of genocide as made by the Special Committee to investigate Israeli practices affecting human rights of the Palestinian people and other Arabs in the occupied territories. That would elevate the stakes from the illegality of occupation to the Commission of Genocide, raising the political and legal stakes. Second, in such a determination of non-compliance, the General Assembly could also try to muster its power and formulate specific consequences. Here, the apartheid resolutions of the 60s are a highly relevant precedent. In that situation, the General Assembly moved beyond condemnation, beyond determinations of non-compliance, and recommended collective measures, calling on all states to cease trade and financial relations and to end arms transfers to the apartheid regimes. These resolutions represented the Assembly at the height of its assertiveness under the Uniting for Peace framework. In the present case, the Assembly could follow this example along similar lines, urging states not only to withhold recognition and non-assistance, but also suspend cooperation that sustains unlawful occupation. And finally, the Assembly can set in motion an institutional follow-up and monitoring. Again, the episode of apartheid in the 60s provides a relevant example. After deploring South Africa's failure to comply with the prior resolutions, the General Assembly created the Special Committee Against Apartheid as a standing body to review the situation. The General Assembly in this case could do the same, perhaps working with or based on the work of the Special Committee to investigate Israeli practices in the occupied territories. That would embed the legal consequences of non-compliance into the fabric of the United Nations, ensuring sustained attention and cumulative political effect. Through these instruments combined, the General Assembly could convert political pressure into institutionalized enforcement, using its powers at its fullest potential. And let there be no misunderstanding. I do think in a given situation, this is exactly what the General Assembly should do. But that does bring me to my last, and slightly more reflective point, entitled The Limits of Enforcement and the Problem of Institutional Competence. And here we reach a paradox, because precisely in using the full powers of the General Assembly, the Assembly will expose the limits of its powers. History has shown a recurring cycle of condemnation and inaction. Over decades, the General Assembly has repeatedly censured Israeli annexations and use of force. In 2024 alone, 17 times. With that long record of non-compliance, one should ask the question, what would be the added value of yet another determination of non-compliance? Despite everything I've said, the deadline itself and any determination of non-compliance will remain non-legally binding. No legal consequences will flow from anything that the General Assembly will say on non-compliance. The legal consequences that do flow from Israel's conduct already flow from the law of responsibility, in particular the obligation of cessation. The General Assembly cannot add anything to this. Similarly, the legal consequences for third states of non-recognition and non-assistance also flow from customary law of responsibility and from the ICJ's opinion. Again, the General Assembly cannot add anything to it. And if the General Assembly is not well positioned to create legal obligations, it is certainly not well positioned to enforce anything on the grounds. This non-compliance and the lack of powers of the Assembly expose a systemic impasse. The United Nations can diagnose the breaches of the most fundamental norms of international law with increasing detail and increasing precision, yet it remains structurally incapable of ensuring compliance with those very norms. Many scholars have observed that it's a paradox that the gravest breaches of international law are those for which enforcement is least available, and that applies here fully. The General Assembly can mobilize the authority of the International Court of Justice, but it cannot compel compliance. And that brings us we risk here the culmination of what has become a ritual, a performance where the General Assembly keeps on condemning Israel, and Israel continues to do what it is doing. The General Assembly resolution becomes part of the status quo scenery, not a tool for change. And that brings me to my final observation. The General Assembly's 12-month clock has transformed the authority of the International Court of Justice opinion into a temporal benchmark that is highly useful. At the same time, when that clock runs out, as it has done the past month, it may mark not, or at least not only, a triumph of legality, but it will also expose the moment when the law's limits are fully exposed. Thank you, and we can take this further in discussion.
Thank you so much. Thank you so much, Professor Nollkaemper. Dr. Spadaro.
Yes, good evening, everyone. Thank you all for coming, and thanks to the organizers for having me. So I want to pick up on some of the points that Professor Nollkaemper touched upon, and specifically talk about the obligations of third states. Because both the International Court of Justice and the General Assembly made it clear that states other than Israel also have certain obligations in relation to the end of the unlawful occupation. The reason why that is because, very simply, from an international law perspective, many of the obligations that Israel has been violating have erga omnes character, which means that all states have an interest in Israel complying with these obligations, and the non-compliance should be or is of concern to all states. The obligations of third states boil down to cooperating to bring an end to this unlawful occupation, not recognizing as legal the occupation, and not rendering aid and assistance to its maintenance. Third states have a particularly important role to play because it is clear that Israel has no intention whatsoever of complying with the advisory opinion. And this is clearly evidenced by the fact that the clock has run out, of course, as Professor Nollkaemper mentioned. But it's also, I think, even more importantly, evidenced by the fact that Israel has actually taken steps to further entrench its unlawful presence in the occupied Palestinian territory since the advisory opinion was issued, which means that Israel must be made to comply with its obligations. And to be clear, I believe that states should have taken these steps to ensure that Israel puts an end to its internationally wrongful acts, even before the expiration of the deadline, arguably even before the advisory opinion was issued, because, again, as Professor Nollkaemper mentioned, these obligations do not arise from the advisory opinion itself, but from the law that has been breached. And indeed, we already had 20 years prior an authoritative finding by the ICJ, the Wall Advisory Opinion, where the court had said clearly the settlements are illegal. The route of the wall was also illegal insofar as it was built inside the West Bank, that this could become permanent, create a de facto annexation, and now all of these risks have fully materialized. And so it's clear that, of course, it is Israel that has been violating its obligations, but it is also third states that have been consistently failing the Palestinian people. We're now at a moment of unprecedented grassroots solidarity with the Palestinian people across the world. But for the most part, insofar as governments are concerned, we see symbolic, if not merely performative, solidarity, even though they do have a legal interest, as I was saying, in compliance by Israel with its obligations. And it is also, I think, noteworthy that these crumbles of solidarity by third states have been given not in response to the unlawful occupation and everything that comes with it, the mundane forms of violence that Palestinians have been subjected to for decades, the creeping annexation of their land, the violence from settlers, and so on and so forth, but only in response to the most spectacular form of violence, what is now recognized widely as a genocide, and a genocide that is being live-streamed by its victims. And so, as the ambassador pointed out, in this context, action by third states is not an act of charity, it is a legal duty. So what is it that states should do? There are a number of actions that were indicated by the International Court of Justice and by the General Assembly, but I want to focus on economic measures. And the reason why I chose this focus is because I think we often think, at least in international law terms, about the occupation in humanitarian terms. And of course, this is important. I am someone who spends quite a lot of time thinking about humanitarian issues. There are also perhaps ideological drivers, of course, to the occupation. I'm not saying that these aspects are not important. But I hope in the time that I have at my disposal that I will convince you that, first, the occupation has an important economic dimension, and second, specifically because of this, economic measures are an important, perhaps even the most important leverage to ensure compliance by Israel with its obligations. So concerning my first point, the economic dimension of the occupation. This was briefly analyzed by the International Court of Justice insofar as it dedicated a few paragraphs of the advisory opinion to the exploitation of natural resources. And in particular, it found that water, minerals, land, and stone are exploited by Israel and specifically by Israeli companies to the detriment and the exclusion of the Palestinian people. This violates a series of rules of international law under international humanitarian law and also the principle of sovereignty over natural resources, which is a corollary of the Palestinian people's right to self-determination. But this is really only the tip of the iceberg of the economy of occupation. Already in 2016, the Human Rights Council decided to set up a database of companies that are active in illegal Israeli settlements in a variety of sectors. To date, this database lists 158 businesses, mostly Israelis, but also American businesses, Dutch businesses, French businesses, and so on and so forth. And this is not even the most comprehensive database. There is an NGO, the Who Profit Research Center, that I believe is based in Israel, actually, that lists 400 businesses. And the special rapporteur for human rights in the OPT, Francesca Albanese, said that she collected information concerning 1,000 businesses, 45 of which she explicitly named in her latest report. So all of this research, plus further research by other organizations, including Human Rights Watch, Amnesty International, and so forth, show that profit-making is closely linked to the existence of the settlements and of the occupation more broadly. So economic actors are vital lifelines to settlements and to the occupation, because this simply could not exist and continue if it weren't for these activities. And at the same time, businesses greatly profit from this illegal occupation. All of this at the expense of the Palestinians. If we zoom out and we look at the macroeconomic perspective, things do not look much better. It is clear that the unlawful occupation is an incredibly lucrative business for Israel's economy as a whole. And it is also at the same time incredibly detrimental to Palestine's economy. And I think this is important to keep in mind when we hear third states reaffirming their commitment to a viable Palestinian state. Because at the moment, Palestine does not have control over its natural resources, its borders, its imports and exports, and its tax revenues. And quite simply, a state that is not economically viable is not viable, and is not stable, it's not secure. We have studies from the World Bank and the United Nations Conference on Trade and Development that speak of the Palestinian economy in terms of de-agriculturalization, de-industrialization, and de-development. And to give you an idea of the numbers that I'm talking about, in 2021, the annual GDP produced in the settlements in East Jerusalem and the rest of the West Bank was 227% of the total Palestinian GDP. I would also like to recall that Israel presents itself as the startup nation, and it is at the forefront of technological development in the areas specifically of military and security applications of technology, with entrepreneurs in the tech sector that have previously served in elite units of the IDF and a variety of corporations that offer essential services to the occupation, for instance, in terms of surveillance, checkpoints, drones, weapons, and so on and so forth. And then are able to market these products abroad as battle-tested, which literally means tested on Palestinian civilians in occupied territory. So as far as the occupation remains such a profitable enterprise, I think Israel has really no incentive whatsoever to put an end to it. And so it is precisely because of this that I argue that economic measures are some of the most powerful leverages that third states have. And if third states are indeed ready to show real solidarity to the Palestinian people, then they need to start putting their money where their mouth is. Which brings me to the second point, which is what is it that third states are supposed to do? The ICJ and the General Assembly laid out a series of measures. It's interesting, actually, that the General Assembly went a little further than the ICJ in terms of what it is that states should do. It mentioned, for instance, abstaining from entering into trade and economic dealings that might entrench Israel's unlawful presence, also preventing such trade and investments, ensuring that their nationals, including companies, do not recognize or provide aid and assistance to the occupation, seizing the import of products from settlements, and so on and so forth. How are states doing in terms of fulfilling these obligations? As I was mentioning, overall not great, especially states that have close economic relations with Israel, particularly Western states. So I will focus on the Netherlands, that claims that Israel is one of the closest friends in the region. The Netherlands currently has a so-called discouragement policy for businesses. It basically says that if a business wants to do, to offer services and operate in an illegal settlement, and before doing so approaches the government, then the government will let them know that they think settlements are illegal under international law, and that operating in settlements is undesirable. This policy was considered, weirdly and unfortunately, I would say, adequate by the District Court of The Hague, in a case that, however, has now been appealed. So we'll see what other higher Dutch courts think. In my view, wrongly, the Dutch Ministry of Foreign Affairs still maintains that it is up to companies to decide where and with whom they do business. This is incorrect because the Dutch state actually has a duty to ensure that private persons based in the Netherlands do not respect international humanitarian law and human rights. And you don't even have to take my words for it. You can read the concluding observations of the UN Committee on Economic and Social and Cultural Rights that were issued just 2 weeks ago about the Netherlands, in which it is explicitly indicated that the Dutch state must ensure that all businesses domiciled in its territory or under its jurisdiction are not involved in illegal Israeli settlements. Obviously, the advisory opinion and the General Assembly resolution were not addressed directly to businesses. They were addressed mainly to Israel and to other states. And nevertheless, businesses are expected to respect human rights and also international humanitarian law when they operate in conflict-affected areas, including occupied territory. Not doing so gives rise to civil as well as potentially criminal responsibility for the corporations, but also for corporate officials. In relation to this, again focusing on the Netherlands, it's good to know that there was a criminal complaint that has been filed against Booking.com, which is incorporated in the Netherlands, and that continues to advertise tourist accommodations in Israeli settlements. I think we do not yet know whether the Dutch prosecutor will take this on, but it is definitely something to watch. It is also good to know that companies are taking proactive steps to comply with their responsibilities. And for instance, just recently it was announced that some Dutch pension funds that used to invest billions in companies active in Israeli settlements have ceased doing so. Personally, I am quite happy that my pension will not come at the expense of the Palestinians. If I ever get a pension, we'll see about that. Finally, or additionally, the Dutch Ministry of Foreign Affairs just a few weeks ago announced that finally a government decree to ban import from settlements is being drafted. This is good news, if overdue. Other countries have imposed limited sanctions on some individuals, including settlers, ministers, and some commercial entities. So far, the Netherlands has not done so, and indeed the former Dutch Minister of Foreign Affairs resigned over failure to secure support for such measures within the current cabinet. I will wrap up soon also, and I would like to mention that, of course, the European Union has certain obligations. It is currently talking about taking steps to suspend the trade-related provisions of the EU-Israel Association Agreement. If you ask me, the agreement as a whole should be suspended. I think it is bizarre that it was even entered into in the first place, considering that it does require compliance with human rights and that Israel has been manifestly and systematically failing to respect the human rights of the Palestinians. The EU still also allows products from settlement onto the EU market, even though this is without preferential treatment, but they should be banned altogether. And in this respect, I would say it is quite clearly not the responsibility of consumers to know whether a product comes from an illegal settlement or not. At the same time, consumers do have an important role to play. This has been showed, I think, in particular in some Arab countries where consumers' boycotts have been incredibly powerful and have forced certain international businesses out. And this is an important form of grassroots mobilization. So I think these are all small steps in the right direction, but still insufficient. Insufficient and prolonged action on the part of third states, I think, further erodes the legitimacy of international law that has been seriously tarnished and tested by the violence that Israel has unleashed in Gaza for 2 years now. So before the same fate of Palestinians in Gaza befalls also the rest of the Palestinian people under Israel's occupation, I think it is time for third states to step up and start complying with their obligations. And I hope to have convinced you that economic leverage is important in this respect. Thank you.